Okay, we are ready to start for Sunrise Desert Vistas Property Owners Association. We're starting at 6:30. Today's the 25th of July. And my name is Grace Violet. I'm president. Pardon me, you want to state your name, please?
Bernie Potoff, vice president. Judge Stroll, treasurer.
Okay. We're here to go through some approval of minutes that we have online already, but we just already approved them. So do I need to say the dates of those minutes? Because I can't do that.
Go ahead.
Okay, the minutes approved were March 8th, March 15th, April 5th, April 15th of 2012. Next on our agenda is to talk about our outstanding attorney bills and administrative law hearings. As far, the treasurer report. I'm sorry, I tried to skip something. Go ahead with the treasurer report.
Okay, right at this moment we have $13,194 in the bank. And we owe $156 on our credit card. I got the profit and loss and the balance sheet up here for anybody to look, and they'll also be online.
Okay. Does anybody have any questions about that?
What's the credit card charges for? And are those being approved tonight for payment? And have the past ones been approved?
Yes.
Yes.
At what meeting were the past credit card charges approved?
At the last meeting, I actually had that answer.
April 15th. So since then, has the association paid any credit card bills that have been approved since the April 15th date?
It was postage and envelopes and things like that. That is basic. Just basic.
I just asked if that was approved. Or are you approving that tonight?
We approved it already because we already had to send out for mailing, so I would have to say that was approved before tonight. But do you want to know the amounts?
Well, I just want to know what all the credit card charges were since
Okay, do
April.
you know the credit card charges?
Not individually, it's just 100.
It's on the internet.
Yeah.
It is online.
Yeah.
When we get a monthly statement,
It just
we
says
put
credit
up.
card.
Yeah.
It doesn't say that what you charge for the credit card. So an individual can't tell.
Didn't I just upload a whole credit card sheet?
It should be.
You have receipts, don't you?
Oh, yes, sir.
Oh,
we have receipts.
There is a spot on the website that has credit card. You click on that, you can see every date, every amount.
Every transaction.
To Staples, Postbox, everything. It's all there.
So you're saying it's online
Yep.
somewhere else?
In fact, if you want me, I can pull it up on my phone.
No, that's okay.
Because I do upload that and I remember seeing it. Okay, so we're moving on. Do you have any other questions?
Not at this time.
You?
I'll go look at the website.
Okay, so we're moving on and we're going to approve any bills that haven't been paid or need to be paid, which are the road grading permits. That was done today. And the reason it's a very expensive bill, and that total is
$2,650.
A bunch of people out here, the door's locked, you can't get them in. I opened the door, can somebody hold the door? I don't want to go get them.
Oh,
That door should not.
we are going to postpone the meeting for a second.
Oh, that's amazing. Everybody came in that day.
All you gotta do is hold it, I'll go get it.
That's very strange.
Yeah, that is.
Well, I can't.
If you do,
You get people in the wrong room.
I think the last time I came for a meeting, nobody ever showed up. Finally, after about an hour, I thought, I think I get down and take a hit.
Well, you may have ended up in the wrong room or something.
There was a couple of rooms in there, we were busy, for those hours.
You didn't recognize anybody then? Good, David. Hey,
I never got
sign
your
in.
email. You were gonna send me an email with a video?
You know what, I already got it handled, so that's why I didn't send it.
Oh, okay, well, I'm glad. I figured you could call her.
It's just been an ongoing, next, I'm so sorry.
Somebody out there.
The door relocked for some reason.
Okay, well, you didn't miss anything yet.
Okay.
Mike, good to see you.
Hi.
All right, well, I actually take that back, you did miss something.
No, not today.
The last
I
letter.
think I'll sit here, close to the door.
Do you guys want to just start the meeting over? Permits.
Are you?
Did you get my message with this
Okay.
court guy was there after? I left on your cell phone.
You were there.
Good. Oh, for your sale? Did your sale ever go through? No.
TW.
Yeah.
Okay?
Hello?
Did you sign in, Carol?
Yeah, I signed for both.
Oh, for both, okay.
I've seen you a long time. How you doing, honey?
What's that?
We'll see her.
Shining Mountain Zoo from in Colorado Springs. You had to buy that? Yeah, I had to buy it. I figured I was going to the zoo tonight. I was wearing a zoo hat.
Oh, are you? Is Liz coming?
She's out with the girls.
She's out with the girls now, having fun now.
Well, eating better than we are, I'll tell you that. She didn't even invite you. Huh? She didn't invite Carol.
See if there's anybody more.
I don't make these things, you know, I'm just like, just get them out of the house.
Okay.
Yeah.
Was it really like awful?
Yeah.
He's watching it.
If I would not have walked down there, but
Oh,
Yeah, I thought you would have got the door off for me. I was hoping.
Did everybody sign in?
That's not her.
Not yet.
Gina. I signed it. Oh,
Both of us?
well,
you should have watched it.
how are you?
Picked up all the strays.
Thank you, Guy.
Maybe you better start from the point of view.
Okay, I think I'll do that. I'm sorry you guys got locked out, had no idea. And my phone was binging me, I just thought I would be rude and look at it. I didn't want to look at it. Anyway, we have a guest tonight. His name is Guy Bluff. He is an attorney. He has come from Phoenix. He's here to answer, or he's here to, if you want to ask him some questions, he can answer them for you. He is not being billed, or he's not billing us, except for he wants a cup of coffee. So we're going to be doing that later for him. And so feel free to ask him anything, because he's here to answer your questions. And we're going to move on.
Why don't you bring them up to speed with what you've already done?
Okay. What we've already done so far is we approved the minutes, we did the treasurer's report, and we can do that again really quick.
okay. We have $3,194 in the bank. We owe $156 on the credit card. The profit and loss and the balance sheet are up here in the front. The profit and loss starts at August 2010 and has all the years forward.
What did you say we have in the bank?
What's your balance?
13,194.
I thought you said 3,000.
Yeah, that's what it is.
Oh, I'm sorry, did I? 13,194.
And the credit card statement is online. We're trying to be really good about getting everything online so everyone can see what's going on. Suzanne?
Just a question for the treasurer. What is our outstanding debt right now? What bills have we not paid? to date, like Lisa Borowski's bill, things like that?
You know, we're gonna bring that up right now. We're gonna stick to the agenda.
If it's not
Okay.
answered, then.
Okay,
then
thank you,
come
fair
back
enough.
to that.
Okay, and that happens to be the next thing on the agenda is Lisa Borowski.
Oh, you were doing road grading.
Road grading.
Okay, the road grading is a bill that has been approved, and today we went down to the county and we bought 2 dust permits. In the past, Sunrise Desert Vista has not gotten dust permits, and they have graded the roads. And you're not allowed to do that because of dust control. So buying the permits, they're good for a year, and we bought 2 permits because one, it was less expensive to buy 2 than it was to buy 1 big one, and the other reason is the roads are going to be graded some on this time and then some on the next time. So that is going to happen as soon as we get your input. We're gonna go home, we're gonna dial the number, and he's gonna grade the roads. We do have a water truck with our bid because these roads need to be done. And we can't wait for the grace of God to rain, because when we want it to rain, it doesn't rain. And now that we have a water truck, it's going to rain. And those 2 bills, the 2 permits cost,
$2,650, but by law, you have to have a water truck out there. So that had to be included into our bid. Now, what we did today was we signed up and did all the paperwork for the dust permit. Now is all we have to do is get approval tonight and do our hocus pocus, and then whenever we say, he'll press the button and the charge will go on the credit card, and we will get our dust permit and we can grade whenever. So we need to make a decision as to when we want to grade. Do we want to wait for some more rain because we know it's going to come? Do you want to do it now and take the risk that it'll rain after it's graded? How do we want to do that? So that's our dilemma tonight, is how we want to do it.
okay, and there wasn't,
She just mentioned earlier, before everyone got here, it was $26.50 for the county permit, but now she just said $36.50? I'm sorry.
Say $36.50.
So, okay, just wanted to make sure, because I just wrote $36.50, so I just want to make sure. Okay. I was like, what permit was that? Okay, $26.50 was the dust permit.
That's for both of
Two
them.
of them together.
Okay, thank you.
Total with the
Right.
water trucks.
What do you have?
well, that
No,
doesn't
no,
count
no,
the
no,
water
no,
truck.
Okay.
That doesn't include any of
That's
that.
just for permit.
Okay.
Yes.
Yes.
We have a situation where if we have one group here and one group here, our dust permits are more reasonable, and it's just easier for us to do it
The
that way.
logic that Joyce found out in investigating this is if you take the whole property that we have, the permit is X dollars.
It's
If you-
$3,000.
If you split it in 2, the permits, the 2 don't equal X. So we split it in 2 to make it 2 different jobs at 2 different times, and you save over $1,000 in permits alone. So that's the logic of that.
It's based on the number of acres
Right.
that are being affected,
Right.
according to Maricopa County regulations. So if you can drop it, if you can break it up into different jobs, 1 acre, 5 acres or less, 10 acres, you can get the lower fee. So it makes sense what they did.
Is a dust permit just for one-time grading, or is it grading any as many times as you want?
All year,
It's good for a year.
all year.
And I must tell you that we did have some obstacles on the dust permit because Sunrise Desert Vista doesn't own the parcels. And so we were really worried about getting the dust permit because we got conflicting stories of saying you have to own the parcel to get the dust permit. And we went down there going, well, we don't own this, but we're supposed to do this, and what are we supposed to do? So we actually went through the line of getting to the top person, going, it's okay as long as we hire a professional grader, and he will be the one responsible for the dust permit. Any questions?
The grader has to have a person who's gone through a dust school. It's actually a class to teach you how to not create particles in the air.
It's a fun class.
I've been through it.
Have you? Well, this grader person has gone through school.
Okay, we had several bids And I want to thank all of you, because I don't know all you by face, but for, you know, donating their time and wanting to grade the roads for, you know, less money. But because of our situation, we want to do just a professional person that's licensed, bond, you know, the whole thing. But we did consider having homeowners grade the roads. So the best proposal that we received was, is it this one?
Yes.
Okay, it's $5,100 to grade the roads with the water truck, and that cost is per occurrence. Okay, so we're gonna have them done immediately, and then we plan to have them done sometime late December. Then the dust permits actually will still be good the following year in July. So we're gonna keep pushing it and pushing it and pushing it, but the roads will still get done twice a year. It doesn't really make it less expensive, but I think somewhere along the line it will catch up to us. All right.
Wouldn't it be better if we graded these now? Because they are been damaged by their last rain, and then it rains again, and it re-damages the roads. So we're not quite out of this. And that would make us regrade sooner, as opposed to next time the logic.
I do.
For you folks there. What's everybody think about it?
Yeah, it seems to me we're just entering the beginning of the rainy season.
So you're saying you advise us to wait a little bit? We can.
It's really hard to grade the roads when it's hard and hot out, when it's not soft.
Although Todd says he does not care which way we choose. He says, I will have my water truck out there, and he says, it's our choice as to when we want it graded. And let's see, there was something else.
Well, there's another issue is that we have a lot of concerned homeowners that are saying the roads are really, really bad to some of the homes, and because they've been neglected.
Here's what you can do as soon as you get your permit. The homeowners who have offered to go out and, you know, do the grading yourselves, maybe somebody's got a Bobcat or something, go and do, because you're entitled without having to bring your water truck or anything else out, so long as you do not disturb a certain area, you know, beyond I can't even think of a quarter acre. So long as you don't disturb that, you can have somebody go out there early in the morning when it's not windy and kind of touch up a couple of the rough areas, and then wait until your monsoon seasons are over, and then do, you know, your kind of your final grading and make your roads nice for the next, you know, 5-6 months. But it would seem silly to, you know, grade them now, because you're going to have the downpours for the next 45 days, you know, through the middle of September. That's what I would do. If somebody's got a tractor, have them go out there and clean up the rough spots and not worry about it. And then you pay your $5,000 to the contractor to, you know, make them all pretty.
So you're saying get the dust permits now. The dust permits are all signed up for, and all he has to do is push the button.
Get dust permits now, absolutely, that's a good idea.
Okay.
That way you don't have any problem with county coming out and saying, you know, the guy on the tractor, you know, go through his training or whatever, you can just say, hey, I'm just, you know, dressing up. I'm just doing weed control.
Rosie?
And then I think the investigation that I did on the roadways, they said if you grade, you know, right after the monsoons or during the monsoon season, you grade again in December, then we grade again in like February or March, and then catch it again just before July. You're getting some really good grading, and then the road's going to get to a point where it's really going to be down to a base that's good, as opposed to now we go so far in between that it gets to be really bad again. So I understand from the contractor that I spoke to is that if you grade, you know, frequently on a couple of months interval, it's going to be better for the roads.
You know, 144th is already been graded, thing with Asher Hills.
Well, that's why we're here tonight, for you guys to put in your input. Because it's very hard for the board when we're getting emails going, when are you going to do it, when are you going to do it, when are you going to do it, you say you're going to do it, you didn't do it. And then I have other issues like this where should we wait?
Who's the contractor that's been hired to do the road grading?
That would be E.D. Smith Paving.
And you said Todd, is that related to Steve Todd Hunter?
No.
ED paving, you said?
E.D., like Ed Smith Paving.
And he's licensed and bonded and everything.
Yes, he actually has graded the roads before. Joseph Benedict, he hired him once before and used him in the past. So he's familiar with the area and the streets. So can we move on?
We haven't decided. Michael?
I agree. I mean, if we can do any sort of little maintenance in between before monsoon season ends, then not do any.
I think some of the problem that I hear is that the roads we don't live on, because everybody sitting in the side of the room is on the same street. So we don't see anything else down on Dove Valley and all, or whatever, these streets are a point of contention.
They're
Yeah,
bad.
one parts of 140th and Dove Valley are bad. You have to road open this morning.
There are some that are bad.
Bone Mountain's pretty bad.
144 have been graded.
So I say we go ahead and get the permits and start the road grading the next
So
couple of months.
Okay.
Well, and if we do that, and we do it again in December, and we plan on the next 4 doing it in February, I think we can get these roads kind of under control. Because nobody wants anyone to get hurt.
Yeah, unless we change the slope of some of these roads and change where the water runs, get some control over where the water runs across the roads. So the water is going across the roads in designated places instead of running down the middle of the road and leaving ruts. We're always going to have problems on the road.
Okay, but you can't change the grade of the road.
No.
You can only maintain.
You can change the crown of the road, and you can control where the water goes across the road in places.
Still good.
As far as I, I don't want to have that flood control guy on my door.
Well, I did some investigating as far as whether you needed a permit through the county, and they said you can't maintain what you have, you cannot change.
You can't change.
Or deviate from what's there. That's kind of what they said, you can maintain, so you can't deviate. In other words, you can't change a wash, Exeter, ingress or egress from a wash.
Go down a rabbit hole for that, because I was never something I was trying to get something on this property.
Well, remember, we need to grade, the board needs to get the roads graded twice this year, so, I mean, the longer we wait, the less, we're gonna have to do it twice before December, so the sooner we might as well do it now and then do it again in December.
So we're agreed, we're agreed then?
We're agreeing. Right.
Well, I don't know. I agree with God.
Well, I have a question, which I don't know if anyone's looked at it. According to the treasurer's report, we have 13,194. The permit road grading of 2,650, and if $5,100 leaves us $5,440 in the bank. I don't know what the outstanding is, but that means that if we have to grade twice a year, that you only have $100 or $200 left plus whatever outstanding is there. So you're not looking at a lot at this point either until next year financially.
Not that.
And I don't know what additional bills you're gonna have to pay. But that would, if this meeting room costs us what it did for our last election, $150,
It's $50.
or 70. I'm just making a statement that there's not a lot of money with 2 road gradings based on the budget that's here.
So if we don't have the money in December to grade the roads, it's not gonna grade.
You still have some money outstanding that hasn't been collected.
Do you know how much?
I think they do.
We got about 5,000 in outstanding. A lot of that's late fees from last year.
Actual,
Accounts receivable.
okay, not including the late fees, just how, approximately, I mean, if it's $66 for homes, how many homes
We're talking
approximately have
last
been
year's
paid?
late fee. We haven't assessed any late fees for this year.
There's about 15% of the people who haven't paid. A portion of those haven't paid last year and this year. Some of them just owe this year, but that's about 15% of the people are.
And that's also
outstanding at this point.
including some people own 3 separate lots. We just have no way to contact them, but we are working really hard to track them down.
You have paid off Lisa though.
Okay,
That is-
we're gonna get to that in 1 second. So is there any other questions so we can move on to the Lisa Borkowski bill? Okay, let's go
Okay.
ahead.
We all know that Lisa Borkowski, Borowski, thank you for that. We had the bill from her running the election and any input that she gave to all the board members and extemporaneously or not. And her bill had a total of, before any payments were made to her at all last year, beginning of this year, the actual bill was approximately $17,200. She got paid $1,500 in advance, $500 so-called to run the election, and $1,000 as contribution to the balance outstanding at that time, at the beginning of the year. So the actual bill before any payment was $17,200. The net of what we owed her was $15,700.
Can I go in right here for a second?
No.
I have to. And that's how I end up calling.
Grace.
Gosh. Okay. Go ahead.
No. So, I will give kudos to Grace, who talked a lot with Lisa. Lisa had made an offer, and Grace made a counter offer, and we ended up paying Lisa an additional $5,000 over the $1,500 that we paid her, for a total of $6,500, which completes the whole bill of $17,200. I think that's a good job. Good night.
And a lot of that was, we were very concerned about going to court, and it's a lot of work. And we weren't disputing her bill in the fact, we were only disputing her bill because we hired her from one date, from a start date to an end date. So we already had agreed to pay the bill for this time. Now, if going into litigation, we could have gotten another attorney, which I don't think we could have found one on earth, because we did try for the 15, it actually would almost come to another $5,000. So really, we only extended her bill $1,500 of what we've already agreed that should have been the bill. So I think we did a really good job. Does anybody have any questions?
So were you able to resolve her bill finally for the additional $5,000?
Yeah.
Yes.
Okay.
And she also took care of, after our meeting today, if everyone doesn't have a problem with that, she's willing to move forward and she'll file the dismissal.
So right now you have, and this is kind of where I got involved, was evaluating and reviewing the lawsuits that have been filed by Lisa's against the association. And if I recall, there were a number of offers and counter offers. I'm actually surprised that she agreed to the $5,000. But the amount of, she filed a lawsuit against the association, and that would have gone to mandatory arbitration. Because you are an association, you would have had to been, by statute, you're required to have a lawyer. Most of them charge more than I charge, which is a cup of coffee, which I still haven't gotten. So you would have spent, $3,000, $4,000, $5,000 just making an appearance and doing the like, having counsel. So negotiating it for what amounts to, it sounds like another $1,500 was, very reasonable in light of the litigation costs that you would have been exposed to. But as I understand it, what you're at now is that you need approval from the association, approving the $5,000 settlement, and then once that's settled, make the payment to Lisa, and I'm assuming she'll follow up with her promise of what amounts to a notice of voluntary dismissal with prejudice, which puts all of your past dealings with her behind you. So,
And that's what we have done, and with our agreement as good faith, she asked us to show her the money, and we did show her the money, and we kept our promise and overnighted it to her. And instead of driving it down to her, which is pretty far for us that live out here, we just overnighted it through the post office because it was only $18 versus I think it was 69 miles round trip and for the price of gas. And the association does believe that we need to recoup some of the money of driving all over the place because we do live far, so we have discussed it and have agreed that 55 cents a mile is rather reasonable to get some of this stuff picked up and dropped off and so on. Does anybody have any input about that?
You just said you sent her the check, but then he's saying we need to get approval, or
No,
we're getting approval?
what we
from the
agreed on,
members?
what we agreed on with Lisa is that we would send her the money. And so she knew that we really were intended to pay her, and she knows that we have a meeting going on tonight. We asked if she wanted to be here. She didn't have any reason to be here. She knew we had to talk to everyone here and get their input, and if something crazy happened, then she will hear from me tomorrow. And we both discussed that probably nothing crazy was going to happen, so that's where we are. So if something crazy happens, she's willing to
So she's got the
understand.
check, holding it until you tell her to cash it or rip it up.
correct,
Well-
it's been transmitted to her in trust as lawyers.
Gotcha.
She cannot cash it until it's been authorized for disbursement. So, you know, the purpose of tonight's meeting was so that everybody would have the opportunity to ask questions about, and provide your input as to whether or not you thought that it was a fair and reasonable settlement, or whether or not you wanted to, you know, litigate with her or whatever. So she's not authorized to cash the check, but she is authorized, and you can send money to a lawyer anytime you want, because the nice thing is that they cannot cash your check or spend it. So, and if they do spend it, you get to go to the State Bar of Arizona because they have a client fund that is designed for your benefit to protect you when lawyers steal your money.
I move we approve it.
I see.
You guys are okay? I think she was very fair and reasonable. And we got a box this big of nothing but emails. There's a lot of emails. Okay, so the Chad Caffer bill is already settled. The responsibility of the Chad Caffer bill has been taken out of our hands. And we did know about this about, I don't know, a little while ago, but we just weren't sure on all the little details. And as far as, I can actually hope that Guy can explain this better than me on the petitions to the Fire Safety and Life, how that really works. All we've done is answered them as far as the loans go. We have been beating ourselves up, getting all kinds of attorney papers. When the Violetti case happened and the Given case happened, these two cases merged together. And when they merged, they said, everything that has happened between you and you and you and you and you is all gone now, and we're all gonna settle this matter. Stop fighting, stop the attorneys. Then the insurance company got involved, and they came in and they said, nobody really wants money. They just want to be right. So the insurance company came in and said, I'm going to pay you, 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 to all the attorneys that were involved. And they said, we're all going to agree, this is what our agreement is. So all the parties that were fighting, old board, new board, who's the right board, any of that, all of that. Putting liens on people's houses, not paying the $400 assessment. Some people didn't want to pay the $400 assessment. There was a lot of stuff going on. So it threw a whole bunch of pieces of paper in the air, and it started a lot of lawsuits. The insurance company came in and stopped them, and everyone agreed. Then a new board came on, okay, and then that board went and saw Lisa Prokowski, and she said, you're not legal, you know, you should get legal, and that started that bill. We've settled that bill, now we have a legal board now, we're moving forward, and the petitions come in because there's 3 petitions. One is for saying the old board, new board still has issues, and they made a whole bunch of loans out to people, and they want the board to pay them back. The board's position right now is I don't have any legal notes. I don't have anything that's signed from any of these people, except for by the board members loan themselves money, okay? Everything I can find and every free advice I can get tells me they're not allowed to do that. And I'm not the law and I'm not the judge. So what we've done is that it's in this place that I guess takes hearings, and even though in the Violetti case and the Given case, a judge already ruled on it and said no matter what's happened, no matter what's owed, you can't get your $400 back, you can't charge the $400, and any loans, notes, any unforeseen stuff that's happened between you guys is over. And they agreed. So the board's position is we don't need to pay the notes back because the judge already decided. That's our position. Are we right? I don't know. Are we wrong? I don't know. But it costs them $500 to do this. It costs us nothing to fight it, and I'm not even sure exactly what this administrative place is, but maybe Guy could help us understand that.
Can you go back to the CAFR bill you skipped? The CAFR bill you said was settled, and then you went into all this other stuff.
Okay, the CAFR bill was taken by some board directors, and one of those directors has assumed the bill and the responsibility of the bill. And as a board, we're fine with that. Anyone have any questions?
You mean an old board member who was on the board at the time has assumed?
It was actually the board member that actually signed for the attorney. Feels responsible for the bill and wants to pay it or take care of it. And has released the board, Sunrise Desert Vista, and the homeowners from any responsibility of that bill.
And CAFR's office has been notified of that?
Yes, I have talked to him personally.
Okay.
So do you think you could explain to us about what exactly the AL or the fire
Sure.
safety?
And I'm pulling this up from memory, and as I get older, my memory is very short, so you'll have to be patient with me. But what essentially happened is you had individuals who have filed a complaint with the Department of Fire Safety, alleging that they are owed money for past grading services or whatever. It's like $20,000 or something. And when I was talking with Grace about this, I said, well, the Department of Fire Safety lacks jurisdiction, legal jurisdiction to hear a complaint relative to some debt. I mean, their purpose as a board is life safety welfare. You know, if there was a problem with, you know, one of your neighbors was not cleaning up trash on their property, you could report that to the Department of Fire Safety. And I mean, they have very limited jurisdiction. So it was surprising to me that the board even took jurisdiction of this complaint. And I think there are 2 complaints, right?
There's 3.
3, okay. But they all relate to an underlying debt for payment of money.
The promissory notes.
Debt for payment of money.
Well, that's one of them. The second one is going back to the old board, new board, and who can run for the board.
Yeah, don't care about that one.
Right,
They lack
and then the
jurisdiction
third
there
one-
too, and the third one is?
The third one is that when a homeowner bought the property, they were told there was no debt because the board felt they had no debt. And because of this outstanding $20 issue or $20,000 issue in the CAFR bill, which the board had already known,
Okay.
and
No, the board
still,
at that time did. When that house was bought, the board did not know about CAFR.
okay,
Well,
well, we
regardless,
never knew about the bills.
None of the complaints does the for none of the complaints is there legal jurisdiction to hear them. And so I told Grace that what needs to happen is that you need to essentially file what's called a motion to dismiss. Motion to dismiss for lack of jurisdiction is very common. The way the administrative law in Arizona is set up is that when you have an agency complaint, you could file one yourself for any purpose, with the registered contractors, with any number of the state agencies. And the agency, they get the complaint, just so long as it's on their Mickey Mouse form. And I hope you're recording that, because it is. Most of them are Mickey Mouse. You get it on the Mickey Mouse form, you sign the form, and you submit it, and they start their little agency action. And they send a copy to you, and then you write down literally a one-line statement that says, I deny. And as soon as that happens, the action becomes judiciable, and it goes to the Office of Administrative Hearings, which is downtown. And they have administrative law judges, about 14 of them down there, whose job it is to hear and make rulings relative to state actions. Either or both parties are entitled to be represented by counsel. There's not an award of attorney's fee. You can go to state agencies all day long, and if you lose, the other side doesn't get their attorney's fees. If they win, they don't get their attorney's fees. It's designed to allow you to address your grievances regarding violations of statute. Failure to pay a promissory note is not a violation of statute. Failure to have the board disclose a prior debt is not a violation of statute. Each agency has its own jurisdictional grounds for matters that they're entitled to hear. Unfortunately, the agency themselves don't make a determination as to whether or not it's within or without their jurisdiction. They require an administrative law judge to make that determination. So you could file the most frivolous complaint ever and submit it to an agency, and this process has to go through its natural completion. It is a complete waste. If you want to know why we are in debt in Arizona, it's because of this crap. So what can happen is that you can go to each of the hearings. They're generally set for, some of them are telephonic, it depends on the judge. Some of them are in person. They're all held downtown at 1300 West Washington at the Office of Administrative Hearings. They're generally set for a half day. People come in and present their evidence, much like an arbitration, if you've ever been to arbitration. The judges have all of the same power as you would imagine a Superior Court judge would have. The judges are all very smart, and the first question that the judge will ask is, why do I have jurisdiction here? But he needs to be prodded, and that's what a motion to dismiss will do. You could file a motion to dismiss on all three of them. Unfortunately, the administrative law judge will not rule on the motion until the hearing. The boards, like yourselves, have to be represented by counsel. You could go in and represent yourself, but there's that old adage about it, only a fool represents himself. So you do need to kind of go through this, because what happens if nobody raises the issue of jurisdiction, the judge could say, well, because lack of jurisdiction is a defense that has to be raised. So if there's nobody there to say the magic words, where the hell's the jurisdiction, the judge can issue a finding against you, which could say that the board is liable for $20,000 or whatever. And the decision of an administrative law judge, although it is appealable only on certain grounds. And so, you end up and then you have to hire lawyers to go to Superior Court. I mean, it becomes this morass that you need to just put a cork in right now. So I told Grace that, from, an overall standpoint, I wasn't going to get into the merits of any of them, because you don't need to argue the merits. Why look at the big picture when you don't need to get past the fact that they should never be able to present their case. So that's what's going to happen, is you're going to need at some point to probably retain counsel to at least draft a simple motion to dismiss, a couple of pages long, on each one of them, so that when the judge does have the hearing, that he's already has that in his hand. And trust me, the judges are really smart. They will have pre-read this entire file, and then as soon as he gets into the hearing, he's going to look to the complainant and say, why do I have jurisdiction here? And that's kind of what you need to have happen on each one of those three. That would be my recommendation. Yes, Grace?
One of the things I asked you was, because the association has very little money, and the important thing is that we get the roads graded, because they've gone a very long time without being graded, so we have almost nil money. Is there, when we had called before, we seem to get a lot of attorneys that, you know, they want X amount of dollars up front. What would be the best way to get an attorney for the association without getting a $20,000 bill?
The problem that you guys have is that you're all litigious. And as a lawyer, you know, I wouldn't touch your board with a 10-foot pole. I'd never be retained by your board. And I think most of the lawyers would have most of the good lawyers are going to have the same problem, is that they're afraid that what will happen, and it's very common, so please don't feel like I'm picking on you. I mean, this happens all the time. Association members get, you know, they have disputes, and then the lawyer gets into a conflict situation, and, you know, if it's an ethical lawyer, they're concerned about conflicts of interest and the ability to continue to represent. Most lawyers, I think, want to do a good job. But, you know, you guys have burnt through, I don't know how many lawyers in the last, you know,
we're on
5
lawyer
years.
number 11 and over $650,000.
Yeah, I mean, it's insane. It really is. The fact, I mean, my personal opinion, I thought you did a great job on settling Lisa's bill. I wouldn't have paid Lisa a frickin' nickel.
You wouldn't have paid her?
I wouldn't have, because I thought that she overbilled. I was, as a lawyer, and to give you a little bit of background, I'm a trial lawyer, been practicing for over 25 years. I also used to be associate counsel for the State Bar of Arizona. I did ethics matters. I used to be a judge pro tem. I've sat on the bench as a Superior Court judge, as a commissioner. I have a very varied background in terms of being on both sides of it. I'm an arbitrator. I'm appointed to a number of panels. I do complex litigation for a living. I do construction litigation for a living. As a matter of fact, I own a construction company that grades roads. You know, I've got a kind of a pretty good background. I was offended by Lisa's bill. I was offended by her emails to Grace. I was offended when I read, you know, a lot of this stuff. As a lawyer, it bothers me when other lawyers do things that I don't think are ethical. Lisa, in my opinion, had a duty to keep the board reasonably informed regarding if she's retained for $500. If you hire me to do a service for $500, and I send you a bill for $750 because maybe things went a little bit beyond what I thought, you know, that's too bad. But if you retain me for $500 and I send you a $16,000 or $17,000, $200 bill, somewhere along the line, I should probably send you a few emails. I just want to let you know, I don't mind doing this stuff for you, but you know, this is going to cost you, and at $300 or $400 an hour, it gets expensive very quickly. Lawyers have a duty to their clients to keep them reasonably informed. That's what offended me about her. She failed in that regard. However, you could not litigate that case for less than what you settled it for. So you actually saved money. You did your job as a board, which is to maintain the finances of the association. I think you did a great job.
And we just really didn't know really a lot of the things because we were not the board that hired her.
Right. So anyway, what you have is a situation where you guys have gone through so many lawyers, and you know, there's a videotape today, and I don't know what that's all about, but apparently you've got your own lawyer, and I welcome that. These are public meetings. These are open meetings. You know, do I think that it's fair for somebody to be able to, you know, videotape it? They videotape, you know, City of Scottsdale and City of Phoenix, and they show up on the internet. Do I think that it's fair that you should be able to go through and purge and edit and do your little YouTube video of, you know, what they said, like they do with Barack Obama and Mitt Romney? You know, they got these little snippets, and that's apparently the soundbite that you hear. No, I don't think that's fair. I think that was fair. So I think you're going to have a hard time retaining good, competent counsel when at the end of the day, they feel like they're gonna just get sued, or they're just gonna be ground up and you know, and thrown under the bus. It's one of the reasons why I'm not charging for this evening, because I don't want to be retained. I came here to be a facilitator and answer questions. I want you guys as association members to know what your rights are, and to know whether or not the board is doing its service to you as association members. That's my job as I see it. So, I think you now have gotten rid of one. Congratulations. I think you have 3 more that, probably could be done in the nature of a motion to dismiss, but I think what you're going to have is a judge saying, well, the association has to have a lawyer to represent them. So maybe you enter into an agreement with somebody where you say, okay, you're our, legal counsel of record, but,
Who would you recommend?
I don't know that answer. I think what you want to try seriously is to file the motion to dismiss, and I told Grace I did this guy for you guys, but I might charge another cup of coffee. Draft it up so that she can send it out under her signature, so that the judge has, because you might get lucky, the judge might dismiss it. And then I don't feel like I've got a conflict of interest, because I haven't been formally retained. And I'm just doing my civic duty as I'm supposed to as lawyers. Because as lawyers, did you know that every lawyer in Arizona is required to give back 50 hours of service to the community a year? Do you know how many lawyers actually do that? There are 18,000 licensed lawyers in the state of Arizona. If every one of them gave 50 hours back to their community, which is what our Supreme Court tells us that we are supposed to do, can you imagine how much free service that we were supposed to be providing to our community? It's actually our #2 ethical obligation, is to provide service to the courts and service to our clients, and then service to the community. So anyway.
What's number 1?
Huh?
What's number 1?
Apparently, to bill the shit out of their clients.
I might clarify the 500 that Lisa billed for the election. There was other things that she was doing for us besides the election, so we did
I
know
got that. I read
the
that
fees,
file.
yeah.
Yeah, I went on holiday and I read that file.
Okay. Just one second.
Does anybody have any questions for Guy pertaining to any of the petitions and how they work? Because he answered them way better than I could on what it is, how it works. We did file for a motion to dismiss. And now, they file something, we file something. We don't even know what we're doing. We're just like, okay, it looks good. We're just trying to do it for free.
Have you actually filed a motion to dismiss?
We did.
Okay, good.
We did, and then they filed a motion to dismiss, and then we just, there's so many, it's all like, now I'm playing like jumping jack, and I'm like, are you kidding me? So.
On this motion for dismissal, does it have to be exactly written, or how do you write that?
No, the advantage to administrative law is that it is very, most of the judges are used to people who are acting pro per. And I actually think that their job is a lot harder than most of the.
Well, Guy said he'd help you with anything, so.
Well, it probably does need to be done professionally. I mean, I will tell all of you that.
But if it's already filed, it's already filed. Right?
Well, I don't know if it was filed right. I mean, I'm not an attorney.
It's all online.
I mean, I've been in a lot of courtrooms, but.
Online, Grace, you did a good job.
Yeah,
I think you did
Gracie
for
has
not
done
being
an
an attorney.
unbelievable job on the
I've done a
website.
lot of reading, and
You get your
wouldn't want to be
username
an
and password
attorney.
under
Okay,
current
we can do
events, you can read all of the petitions, everything.
I think I'm taking over web designer now, because we have over 700 uplinks now. So I don't know if we're doing the right thing. We're still looking for an attorney, because it would be nice for me to sleep, and honestly, it does keep me up.
Can I ask, what is it that you think you need a lawyer for? Because most associations don't have this much litigation.
Well, one, I'm concerned that I'm not going to do the right job for the community, because they're looking up to the board, and I don't want to make a mistake. I just don't want to, I just don't want to make a mistake for you guys. I don't know all the right answers, I'm just trying.
Get Guy to look at it.
Yes.
Yeah, you're not gonna make them, you know, these are, you're given a lot of latitude, just, you know, but, you know, the best thing you can always do is whenever you have a question and you're, you know, notice up a meeting, allow, you know, because they're your representatives. So notice up a meeting, allow them the opportunity to speak. If you guys sit there and say nothing, then you do so at your own, you know, risk. But that's the safest thing that you can do, is simply have regular meetings and say, here's what I'm thinking about doing. Other than paying your monthly bills, which have to be paid, and you can pre-approve in advance. When you come to a question like that, guys, I don't know what to do, ask your members for guidance. And then if it's something that requires action, ask for a motion. Second the motion carries. You know, you are simply their voice. And you don't, you know, and you get to ask them, what do you want to do? You know, there are a few times where you're going to have to engage in executive sessions where you take the input from your members, and then you're going to have to sit back and make the hard decision. That, you know, because some people say, yes, I want to do this, and other people say, no, I want to do this, and then you have to make your decision. However, you know, I think most of you guys have a common goal. You're all neighbors, and you know, if there's something that you don't understand, call a meeting. The failure that most boards make is that they try to deal with individual members on a one-on-one basis instead of allowing an opportunity for everybody to be heard in an open forum. And that includes, you know, videotaping if they so desire and posting it up on YouTube.
So what would you guys like to do?
I'll have Guy help you with the dismissal. Make sure that everything is.
There are no loopholes, because we know what happens in loopholes, with
Pardon?
loopholes from the past. So, just, I'd rather have, like you said, just somebody, if it's a little extra money, to make sure it's done properly. Because I think a lot of people, and I'm speaking for a lot of people in the neighborhood who don't come to these meetings, there's a lot of people out there who are really frustrated with people taking advantage of people's mistakes or things that have happened on the board. We all know what we're talking about there. So let's just cover our butts and try to get along and move forward.
Absolutely.
No, they don't.
Yeah, I think it's great you get rid of the lawyer bills now. We just get rid of these three.
Yeah, we're done with the 2 large bills, and now we're just down to the little petitions. And yeah, it sounds really simple, that it's gonna be out of jurisdiction, but do I really think that's gonna stop this? Probably not.
They'll probably file another lawsuit.
They'll
after
file another lawsuit, and it will go on.
We've got a half dozen people in this area that seem to be very unhappy. And I don't know if we can ever get them happy. 175 lot owners.
Right.
So they're
Like
maybe
sue
have
happy.
suits in other
Yeah,
areas.
do you know how we can prevent that?
You can't.
Guido, liens on our houses.
Hire a Guido.
They constantly hear
A
about
Guido?
What?
I got lots of those. I got lots of Guidos.
Let's move forward, Grace. I think you should motion it.
So you guys are okay if the board spends a little extra money, or?
Sure.
I make a motion that we take advantage of Guy's generosity to review that dismissal paperwork and let him make the changes to it that he deems necessary.
Yeah, he'd offered. It'd be a shame to pass up on that.
Yes, you can.
There's been so many motions and counter motions and
I don't care about
Okay, so the motion on the table right now is that we take
How can you
advantage.
make a motion to ask somebody to work for nothing?
You can actually, because I won't take your money. See, the advantage to me is that,
Well, you wouldn't.
no, I'm quite serious.
You'll take a Starbucks gift card.
No, I don't.
No, I'm
Not
just-
Starbucks, because I despise the corporate entity.
Oh, that's right, yeah.
But if it was, you know, some local coffee shop, it'd be a different story.
That's fair.
Okay.
No, you know, when lawyers start to charge a fee, then then their own self-interest comes into, you know, see, this way I can stop whenever I want.
So how many pro bono hours have you used up this year?
I give, I exceed
Don't even
my-
ask him that question.
I
don't
exceed
even
my
there.
50 hours. I generally do about 200
You wanna work on
200 hours a year is what I do.
Okay.
That's my goal.
Well, you know, it's an offer that we can't refuse.
So, So anyway, I'm not going to be, I won't allow you to formally engage me. I'm not going to be your lawyer. I want everybody, including the videotape, to know that. Because I don't want to be conflicted out in the future. However, I will, if Grace asks me, I will review the motions and try and provide some guidance.
That'd be great.
Thank you.
I'm happy to do.
Thank you.
Applause.
And then the other purpose was really to let you guys know, I give my email out freely. You can ask me questions. You know, I answer lots of questions. I do a lot of blogs. I write, I'm a prolific writer. If I have time to answer questions, Grace knows this, I will. If you send me an email and you're one of the 80 that I get a day, and you don't hit it at the right moment, your email will never get reviewed. And you just have to learn the trick of, you have to resend it, which is really kind of cute. My children have learned that trick, that, you know, if they want money, they have to resend the email. You know, if you catch me at the right time, I'm happy to answer questions when I can.
That'd be great.
And you can ask me really questions on a lot of topics relating to what's going on here. Because if, at the end of the day, if I can resolve things and bring everybody's disputes down, all of you will benefit, and then you won't have to hire lawyers.
Yes.
And their children will starve and won't go to good colleges.
Well, I think we're getting closer, just one step at a time. Right, so I think I'm gonna move forward, and what we have next on here is the new SDV policy of no harassment, no videotaping, and out of order procedures. And right now, the board really doesn't necessarily care if they're being videotaped. I just have a lot of emails with the homeowner saying, I don't want to be online, they've got me on YouTube, they're not playing the whole video, you've got to do something, make them stop. And the other issue is we're not really Title 33, and I want to bring that up to you because in the 11 attorneys that the boards have had, 10 of those attorneys have discussed that we're Title 10. Okay. And what Title 33 is we have these little laws for Title 10, which is a nonprofit corporation, and Title 33 is a corporation that has a planned community. And what a planned community is three things. And the three things that this is, the association must own real property, the association must have been created for the purpose of managing and maintaining the association and property thereon, and members of the association are required to pay assessments. You have to hit all three of those requirements. The association does not own any property, zero. We have no community-owned property. So people think because we have to maintenance the roads, that the roads belong to the Sunrise Desert Vista. It doesn't belong to us. So some of the people have paved their roads out here. It's not our business if they pave them. It's their business because they own their easement. The easement has been dedicated an easement as in community public cross through, but it has nothing to do with Sunrise Desert Vista, except for the exception that our CC&Rs are so outdated that probably once we get them updated, which we are working on, we won't even have to grade those roads. That's what I'm understanding from attorneys, because they're not our responsibility. They're the homeowners. Same thing, we can't get a desk permit because we don't really own the road. It's the owner's responsibility. So as Title 10 says, there are no rules about videotaping, but Title 33 says that you have to allow videotaping, but you can make a policy and with reasonable rules and whatnot. When Guy came tonight, he read our video policy, and it's just saying that you can video, don't video the people, don't throw it out on the internet, give us a copy in 10 days. You know, don't defame it or don't distort it in any way. Just, you know, don't delete sections out of it. Don't put words in people's mouth that they didn't say at the meeting. Just be respectful of each other, and we have copies of that. During this process, we found out that Mohiki, I think is that right? So I say that she offers classes to anyone that wants to go and learn about associations. Bernie and I, because we didn't know anything about associations, I didn't even know what Title 33 meant when I got on the board. I hadn't a clue. Then you go there to her classes, which are free, and there's a little lunch and stuff, and she just educates you on the typical things. So the board did pay her money and said, we have a lot of questions and we've really been taken advantage of by some attorneys and we are just out of money. Can you answer them for me? So you're allowed to go to her little luncheons and ask as many questions as you want. And on the first Monday of every month, is it Monday? Yeah, first Monday? Yeah. I believe it's the first Monday. It's either first Monday or first Friday. It's on her website. And I have these letters here from her that you can go and pull up. And she, on her website, she has all the basic answers to flags and titles. And I mean, you don't even need an attorney once you get to her site. It's all spelled out for you. So she did write this, and she answered a lot of our questions within minutes. And she charged us a very low fee. And she will continue to answer questions, but only from the president of Sunrise Desert Vista. Okay, that's me. So she doesn't get 293 people emailing her. Okay, but anytime you want to look up on her website, you can do that and pretty much get the answer you want just from looking at her website. In this little paper that she writes for me, for you guys, is telling you why you're Title 10 and why you're not Title 33.
You guys understand what Title 33 and Title 10 are?
I know about Title 10.
One is nonprofit and one is whatever.
No, Title 33 deals with property under the Arizona Revised Statute. So Title 33, Article 16, deals with homeowner associations in general, planned communities in general. Title 10 deals with corporations. The Arizona Limited Liability Act is found in Title 10, nonprofit corporations. So Title 10 generally deals with organizations, corporations, partnerships, LLCs, and the like are all found in Title 10. Title 33 deals with a separate class of entity, homeowners associations. So what Beth is doing, and Beth, and I think it's Mulcahy is how you pronounce it.
It could be.
She represents homeowners associations as a living. That's what her law firm does. It's kind of a specialty firm. So what Beth said was, you guys are not a Title 33 homeowners association, not subject to Title 33. You are subject to the general nonprofit organization rules found in Title 10, just the Arizona Nonprofit Corporation Act, because that's all you are. You guys are an organization formed, Arizona Corporation Commission, nonprofit corporation. You have to file whatever is the annual report with the IRS, because you're not here to make money. And it is a huge distinction as to whether or not you're subject to Title 33, which has all sorts of protections designed for association members, in Title 10, which basically says the board can treat you like dirt for an entire year, 364 days, and they only have to see you once a year at the annual meeting. You guys have been acting like a Title 33 board.
Yes.
Under Title 10, no videotaping would be recorded if the board said no. You could impose reasonable restrictions, not just on videotaping, but on the amount of time people can speak, who can speak, whether they have to fill out a little card. They can impose all sorts of restrictions on them. You guys have been much more lenient as a board, because you have a common goal and you want to, play nice with your neighbors. So if you wanted to, as a board, adopt a policy based on Beth's opinion letter, that says no videotaping is going to be allowed, you could do so. If you want to adopt a policy after having allowed your members to review it and comment upon it, public comment, and adopt a videotaping policy, then you could do that as well. So I personally believe that associations, nonprofit associations, benefit by things as simple as allowing videotaping. I think that it makes for open, fair discussion. It makes people, it has a chilling effect on many people that you're not allowed to ever videotape the participants, but you can videotape the board if the board wants to sub-allow it. So I think, you know, kind of one of those.
And how do you
should allow
prevent
for.
them, how do you prevent someone from distorting the video?
You can't, you can prevent people from telling lies about you or distorting the facts. I mean, it's all a matter of perception. You would hope that your neighbors would not do that. One neighbor should never do that to another neighbor.
Amen.
I think we'd all be in agreement to that. Okay, yeah, we want to go on. Did you want to say something?
We said we're done.
He wants to-
We
He wants to-
need to pay $2,793 for our insurance payment. And the problem with the insurance in the past is that if we have one more lawsuit, we have the potential to not be able to get insurance. And that's very, very bad for anyone that has a mortgage. Because if you have a mortgage, okay, and you can't provide your mortgage company with an association, you have to physically get a separate policy for your home and pay a lot of money. So we need the association to work. Now, I don't have a mortgage on my house, but I know a lot of you guys do. And it's a serious thing, so we need to keep working together. The next thing is we have Becky Shepherd.
So we gotta approve it.
Okay.
2,793, we gotta have insurance, E&O insurance for the board. Everybody agree? It was $100 and some more last year, so this year's fine.
I gotta make a motion
Unless
that
we
we
can,
allow that insurance.
unless anybody can come up with something
Retain.
cheaper. It's August 19th is when it's due.
I say we pay it, make a motion, pay it.
And that's second.
Okay.
All in favor?
Aye.
Aye.
Okay.
Opposed?
Anybody opposed? Let the record show no one opposed. Okay, Becky Shepherd was a board director, and on April 8th, March 8th, was it March 8th or April 8th?
Well, when this happened, it was back in January, when they were first elected. We had our first executive meeting, and we had it so we had Gracie president, Bernie vice president, and Wendy Free was selected as secretary. And the day afterwards, Becky went to the Arizona Corporation Commission, expedited it at $60 cost. Gracie was president, Bernie vice president, Suzanne was secretary.
Behind the back of that.
Yes,
voice.
without us knowing, and definitely without the approval of the majority on the board. And she would like her $60.
She would like her $60 back, so we want to get input from everyone in here.
Probably avoid a lawsuit, so go ahead.
Make a motion.
All right, so I motion to pay Becky Shepherd the money for the fee.
Correct.
Okay, all in favor?
And you gotta realize, this is a person who's complained to
Joyce,
me.
vote
The
on the
vote.
motion.
All in favor? I say pay. All opposed? All right, 3
I
opposing.
oppose it.
And one of those is Joyce Stroll. So the motion passes, Becky Shepherd is gonna get paid. Can you put that on there, please?
I mean,
No.
I've been hammered for
No.
$2.17.
Well, we understand that, but we're just trying to move forward.
This one.
Okay. we're
Okay.
moving forward.
The next thing on our list is due. There are a few people that haven't paid. This is probably one of the first boards that's had great success on getting their payments. And I think we're gonna keep moving forward on that, but the board and the community needs to decide, when are we gonna start charging late fees, sticking to the late fees if they don't pay? I say that we give them 30 days, because it's been a long time and a lot of the boards have been in chaos in the past. And I think finally the boards, the community's finally starting to see that it's moving forward in a healthy way. So does anyone have any input on that?
I think whatever you pick, it's gotta stay consistent. You can't
Right.
waver one way or the other, or make exceptions, or.
Black and white.
So how about if I give out one more
I don't think we should
invoice
charge
blast?
any late fees till the end of the year, and then once the new year goes in, we set the policy then.
Well, you gotta do it now.
If you send them one more bill saying, you know, if you don't pay in 30 days, we're gonna start charging you a late fee, you know.
Comes, I mean,
And they've
there
already-
are a few who haven't even paid from last year, although I've called them up, and a few of them will pay, they just don't want to pay the late fees. But I know I'll get more people to pay if I set a date. They will go right to the last day.
And we are calling them.
Is the reason why, this is the question, is the reason why some of these people don't want to pay the late fees because of the dispute that was ongoing, they didn't feel they were going to pay?
They don't know who to believe and what
Yeah,
was
so
going on,
I
so there
think
was a
for
lot of
the,
confusion.
for going ahead, I think we should
There was
remove
a
the
lot
late
of
fees
confusion.
prior, for
Of
anything
the
prior to.
people who didn't
Well,
pay.
yeah, there's
Are the
people who
people who
already
didn't
paid.
pay this year the same as the
Oh,
people
yeah?
who did
Yeah, there's
last?
people who have
No.
already paid.
They're
Well,
different.
then,
We got a
No,
little bit of
but I'll
quality.
give you an example. Here's an example of what's going on right now. I have a homeowner that will pay the $5 per acre, come to my meeting and vote to pay $400, and then not even pay his assessment fee. I'm
It's
like,
66.
it's $66. I'm like, you just voted for $400. You were in my crowd going, I want a $400 fee, but you won't pay 66. It's honestly just silliness. It's just people just throwing, I got emails today saying that the board had approved 100 horsey farm out here. And he's like, answer me right now, answer me right now. I'm like, all right, settle down. My phone's ringing off the hook all of a sudden. I'm thinking, all right, what's going on now?
Somebody's just trying to harass you.
Right, that's all it is. People are just starting rumors out here. I cannot prevent that, none of us can, but I think now it's getting to the point where people are starting to understand the rumor people.
Mike, what do you think?
Has anybody already paid a late fee assessment?
Yes.
They have.
So we have
In the
to-
past,
we have to
in the
charge
past, not this
And you
board.
have to charge it.
It's been done in the past.
Yeah, and last year, we put
No,
a
no, no, I'm
deadline.
talking about for
What are you
this
saying?
Not this, not this
No,
year.
Current assessment. What was the current assessment period?
Well, we assessed it out in May, I
Okay.
believe.
When does your late fee go into effect
We haven't said that for this year,
for this year?
But
So
we
what
told
you're
them
talking about
July 1st.
is last year?
yes.
Okay, well, don't make any changes relative to last year. That would make sense to me. But
Okay.
in terms of what I'm hearing is, relative to the current assessments, maybe not charging a late fee or getting one more notice out that says, guys, at the board meeting of, July 25th, we determined that, if you don't pay by August 31st, late fees are going to be assessed in the same amount as we did last year. They're going to be assessed. That gives them 35 days advance notice. And then the other way that you can get money faster is to put a PayPal button on your website.
We have
Casey's
that.
been working on that, yeah.
I just want to get
They did have a
approval
late
from
fee.
our group.
They did have a late fee a month ago, but they bypassed it, how that works. So
Well,
August
we-
31st would be very good.
Yeah,
We
Yeah,
tried to
they
say it
tried to
was
do
due
that.
July 1st. And like I said, we just have a few
It is
people that haven't
due
paid.
July 1st. What you're saying is we're going to assess a late fee come September 1st. Okay?
Most of the problems though with the people that haven't paid is they're out of town, you don't know how to get hold of them, right? You're not even sure
Right.
you're getting, you
There are
don't even know if
several
they're getting
people.
this.
There's about
Four.
I would say about 10 people who, the four, Wild Horse and the doctor, 4 lots that I just don't have addresses for. I mean,
I remember that there was a
I
lot of
can,
people hard to get
you know,
hold of.
and then,
Addresses for them.
We do, but they get sent back to us.
No, if you go to the assessor's office,
We do.
we do.
okay, so whatever is the notice, because that's the, if you can't find a homeowner, by statute, every property owner is required to maintain a current address with the assessor's office. So if you use the same address as the assessor's office, which is their official address, absent some separate written notification to you of a different address, the assessor's address is the official address. And it is their duty to get their tax bills and, you know, the assessment or whatever it is. So if you ever have a problem, that's the one address that you want to use. Okay.
Yeah, I've used it, in fact, I've used it 2 or 3 times thinking, oh, maybe some postal worker had a bad day, etc. So I sent it again, just in case, but sure enough, it goes back.
Oh, you only have 4 or
Can
5.
you turn the air down?
Yeah, oh, yeah.
Thank you. I was just thinking the same thing. I can't get out of here. I'm suffocating.
Okay, how do we do this? Set, okay, down.
Okay.
Oh, you just press
Right
hold.
to the number.
No, it's not going to do anything because it's on the program right there. You have to do that first and then it'll begin. And then when you're done, you push it back to the program.
So with the participation of the homeowners, you guys want to bill one more time and give them 35 days?
Yes.
Say like by August 1st, they have to be paid.
Wait till the next year.
August
September
31st.
1st, August 31st.
Okay.
September 1st.
And we're trying to call people on the phone. We'll try to get on it, I mean, better. But like I said, there's just a few people that haven't paid. And then there's the other issue that I hear is, I don't want to pay a dime to you people if you're going to give it to so-and-so. And one of the lawsuits. I'm like, I can't promise that. And then there are, you know, the guy, someone came up to me and told me that there was a guy out here buying property and they heard that we were taking deals. And I actually spoke to that guy and he did offer us a deal that if we turn him on to some kind of property that's in foreclosure, I'm like, we don't do that here. Don't make deals like this with anyone and keep the board out of this because it just ran up a big rumor. We don't need it. And he doesn't want to pay the association fees because he doesn't want an association. I mean, he'll pay the fees, he tells me, but not if he has to write it for assessments. So I don't know what to do about that.
Okay. Next one.
What do you guys want to do?
They already sent it.
Just charge them late fees? Okay.
September 1st.
All in
late fees.
favor? Right, all in favor?
Yeah.
Aye. Anyone opposed? For the record, no one's opposed.
Yes.
In regards to that, and I'm sure Guy could answer this a little bit better, once you impose late fees, like you have said, several members have not paid for over a year or 2, at what point is the board going to pursue that money? Because there should be a policy in place that if they don't pay after so amount, and Arizona laws say that after a year, you can start to do things, so I'm sure Guy could fill that in, but this board should probably come up with a policy and notice the homeowners of what that policy is going to be so that it can continue to take action, because $15, you could be charging that forever unless you have a policy that says you're at some point after a year, you're gonna do this or that or whatever, so.
You want my recommendations?
Yes.
Okay, I'm charging you personally a cup of coffee for this one.
I don't drink coffee, but that's fine.
Do you drink? You drink?
Water, yes. I'm boring.
Everybody drinks water, 97% water. This would be my recommendation. You have a right to file and record a lien for, you know, assessment. The problem is that some boards file their liens too quickly, and I find that to be offensive. My recommendation is that unless you know that the property is going into escrow, that you hold off filing your lien for assessments for as long as possible, because there's no reason to do so. Your lien, Arizona is a first in line, first in time, or first in time, first in line rule. So, filing assessment liens just pisses the homeowner off. Don't do that. But if you have somebody who hasn't paid their assessments for, beyond a year, I think your policy should be that the board should approve at a meeting filing a lien. And it's just it's a matter of course. After, it was assessed on January 1st and we're now at the new year, it's gone 12 months, they haven't paid it, file the lien. Because you do need to do that to protect yourself.
Should we put in a letter, step-by-step processes to reach that?
I would probably do the following. I would adopt a policy that says, look, when do you normally send out your bills?
Well,
for each year?
I'd like to send them out the end of the year, and they're due like January 1st. The Giving Board sent it out November 15th, and it was due January 1st. This board, the last board, was really slow.
When you have your annual election?
January.
January, yeah.
Okay, I would, if it were me, I would do this. I would allow the new board the opportunity to send out the bills for the current year assessment. Does that make sense? So your January elected board is the one who would, adopt, approve, because maybe they have an entirely new idea relative to assessments. You don't want to be strapping them with last year's policy when the new board may have a better policy. So I would, if your annual election is always January 1st, second Tuesday of January, I would probably set it so that your bills go out, we'll say February 1st, with a 60-day time period for payment. So due by April 1st. With a late fee that's assessed after 30 days. What's your current late fee? Is it $15? Is it $15 a month?
Yes. Yes. Well, our CC in our state that we have to have it established 30 days before the end of the year. So by December 1st, we have to establish our next year's
oh, okay.
assessment.
All right.
We don't want to carry them over.
All right, so you didn't give me that little tidbit of
That was why they put that in.
But that's sort of it has.
all right, so that makes sense. So you, in your November meeting, you adopt what is going to be your 2013 assessment, which also would include a 60-day payment period, which I think is reasonable, a 30-day grace period, which is reasonable, and then an assessment. How much is your assessments a year? Is it per acre? Or?
It's per lot, $66 per lot, plus $5 per acre this last year.
Okay. So have that voted on in November, send out your bills January 1st, essentially, and give them the 60-day payment period, a 30-day grace period, and then the $15, assessment. It seems unreasonable to me that you would have a flat fee for late fee when if I own 10 acres and it's is it $5 an acre? Yes. Okay. So it's $66 for owning a lot and then $5 an acre thereafter, right? Mm-hmm. So mine might be $136 or $126, whatever. And yours might just be $73 because you only live on a 1 acre lot. But, if you're late a day, 31 days, you get hit $15, but I owe you a hell of a lot more money and I only have to pay $15. That seems disproportionate to me. Maybe it's something that's on the nature of a percentage of your fee. To me, it would seem more reasonable that you would charge a late fee of maybe 15% of the assessment per month or 10% of the assessment per month. Do you use QuickBooks for your account?
Yes.
Okay. You could set up your late fee in QuickBooks as an item that would allow it to calculate based on the underlying charge. It would seem maybe an administrative fee of $5 plus a percentage fee based on what's owed. Okay? Don't ever charge a late fee on a late fee. That's prohibited by statute. But, you know, that seems to be, that would be more fair. It might accomplish the same goal. And then it also avoids the problem where people have a perception of, you know, well, how come I'm having to pay a late fee? You know, when my assessment's only $66 and you owe $400 and, you know, because you own 4 lots and you're a son of a bitch. They told me that before you came in, and I'm just repeating it for YouTube. That would make sense to me, but I do 68, 30-day grace period, flat administrative fee, and then after 12 months, a lien. I would charge a fee for preparing the lien. So it costs $9 to record, preparation time and the like might be 30 minutes per lot. So maybe you charge a, you know, lien filing assessment of $100 that's tacked on to make it, you know, worth your while. Because after a year, you kind of want to punish them. And I don't mean that to sound bad, but you really do. You want to assess them something to make it painful so that they become a compliant, you know, payer, right? Like Cox Communications, everybody else.
Maybe a letter from an attorney or something.
You don't need a letter from a lawyer.
No, you don't want that.
You don't want that.
A little scary these days.
And when you grade the roads, can you just stop at their house?
Go around.
Go around.
Oh, we ran out of gas. I'm sorry.
So their neighbors have to drive over the road.
Just cold calls.
Almost. Okay. The website, the newest things on the website, we're working on getting the PayPal button. And if you use the PayPal button, you'll have to pay like a $10 extra fee to use PayPal. Seriously, if you want to use a credit card, there's going to be a fee. And, or you can just send in a check or drop it off at one of our houses since we're all neighbors. But a lot of people will find it more convenient to pay by credit card. Does anybody have any ideas about that?
Do we have to pay for it if it doesn't get used?
Nope.
It's just
Don't
use
use
it.
it, yeah.
You only pay for it if you use it. You personally.
The person that
use it.
uses it.
Right, the association doesn't get billed.
Yeah, the association gets paid the same amount, but the person has to pay $10 extra
Right.
to pay them.
Well, that's not exactly how it works. Let's say the vape company, let's say your bill is $100 and you're charging that person $100, and we say there's a $10 fee to use this. The bank will take the $10 fee plus the $100, so you have $110, and the bank will say, I'm gonna charge 2.5%. So out of the $10, okay, or out of the whole amount of money, the bank will take 2.5%. The rest of the money goes back to SDV POA. So we actually make money.
Does it charge a flat $10 fee?
No. No, the bank charges 2.5%.
Okay, so you're basically, you have a flat $10 fee as a courtesy fee.
Yes.
Okay.
So you're actually collecting more money from
Is that a
them
profit?
than, I mean.
Yeah, would that be
Is that
considered
violating
profit?
the profit?
It's
No.
not a profit, no, it's a courtesy fee.
Okay, because it is a lot of work for me to do
If the bank
it.
is taking your 2% or whatever out of that $100, technically speaking, you're only going to get $98.
Well, but you're paying the $10, so that covers that 2.5%.
They're really
Okay, so
$107.50.
Okay,
They're really-
so PayPal's only going to get $7.50.
No,
No, they're gonna get.
they're gonna get like $3. And the $7 is gonna come
So
to
we'll get
SDV POA.
107, right?
107.
Okay, I understand what you're saying.
And it's just making it easier, because a lot of people are out of town, and some of our people are in other countries. Okay, amending the CC&Rs, we're not going to amend them tonight, but we are going to send out a booklet that's gonna tell everyone what our late fees are, what our fine fees are, what our policies are, and we have several complaints about junkyards around in the neighborhood, things like that. We need to start saying, we're gonna start stepping up to the plate, you know, making the community take care of business. So amending the CCNRs is gonna be a lot of work. So we need a lot of participation from the community because our CCNRs are so old. It's like my daughter the other day said, what's a pager? I mean, she didn't know what a pager was. I had to explain to her, like, that's this little box. And our CCNRs are old. So we need to get them up to date and all agree on what should be in there, what shouldn't be in there. Because our CCNRs say you can't even have a garbage can sitting out. But yet, some people have had their garbage can for 20 years. And it's a dumpster because they have a horse from the street, but the CCNR say you can't have that. And then you have horse trailers everywhere, but our CCNRs say you can't have a horse trailer. So, but yet we live in horsey land. So we have to get some of them amended.
In view of the roads.
What?
In view of the roadways.
Right, in view of the roadway, which depends on where you're standing on the road, you could probably see it.
We'll take back all.
So we're gonna send out a letter saying we're gonna amend the CCNRs. We're gonna tell you what we think the CCNR should be. And we're gonna have a meeting, the next meeting that we have, talk to your neighbors. Everybody talk to the neighbors and get them in here and let's have a party and really talk about the CCNRs, not in a fighting way.
The problem we've had with this is that a certain percentage of the property owners have to.
You're never gonna get this accomplished.
Yeah, but it's not.
This does not happen. But there's another way,
Okay,
and it's simple.
listen everybody.
I didn't, what was your original comment? I didn't even catch that.
Well, what I was saying was without, I think it's
2/3.
2/3.
66 and 2/3.
66, and then there's another one that says it's 3/4.
The CCNR, 66 and 2/3, and
CCNR,
it's on
and
the
then-
parcels, so it's not even on like a
Right.
unit.
And then you're never gonna get that. You're just,
Okay, so
Yeah.
you'll never
You
see.
don't- If you've got old CCNRs, let them do. But you can adopt rules, and that's how you do it. Because the CCNRs say that you can adopt reasonable rules consistent with the CCNR. And so the things that you're talking about, and all you have to do is come up with your rulemaking authority, which the board is empowered to do. And so what you do is you simply come up with rules interpreting the CCNRs that accomplish the exact same goal that you want. Have your party as you described it, and then have those rules adopted and send them out to everybody, and now you can have some teeth. But if you try to adopt or modify your CCNRs, you're just looking for a battle.
We don't want to do that.
You'll need a whole bank of lawyers.
We definitely don't want that. So are you seeing the rules on the CCNRs? We have to follow
No,
the
they call them
CCNRs.
CCNRs. Those are covenants, conditions, and restrictions. I said you have rulemaking authority, and you're going to adopt rules and guidelines and publish your rules and guidelines, which are consistent with your CCNRs. And
Suzanne, let me give an example, if I might,
Sure.
because we had this happen previously in another association. Our association, the CCNR said that your house has to be a certain color within a color scheme that was aesthetically pleasing. Okay, which leaves a lot of room for interpretation. So the rules said it has to be within a color value from A to B and C, but couldn't be F, G, or E. And when you look at the colors, and any paint maker makes colors which are in a light reflective way, so that you could get your color approved, it was A, B, and C. But if it was E, F, and G, you couldn't get it approved. And that was the rules that followed the CCNRs that set the teeth, if you'll call it, for that to be allowed. So that you're still following the CCNRs, but instead of using a term aesthetically pleasing, what's pleasing to your eye and what's pleasing to mine is two different things. So this way you have a concrete value. So if you want to say, let's use horse trailers, then you may say that horse trailers are approved, but horse trailers with living conditions and air conditioners, because someone could live in there and you wouldn't want, I think that the CCNRs kind of are indicating they don't want like a modular home or a RV parked on the driveway of your neighbor's house as their home or second home.
What
or
actually says
friend's
horse trailer?
house. And so, well, and that's how the CCNRs are a little bit on there, because of the way you read it.
They're vague.
They're
So what
vague,
you
so
do is
you could
adopt the
interpret
rule
saying a
interpreting
horse trailer
that.
could be, but a RV or living quarters kind of RV would not be. And then you clarify that in rules.
Okay, and anybody have any input on, everyone agree to talk to the neighbors, let's get them involved in that?
I'm glad you got Guy to help you.
Okay,
We appreciate
and
you.
I'm just a wealth of knowledge, aren't I?
I mean, if we're done, I just had a few final questions for the
Okay.
board. If we're done.
we're done.
You said the CAFR bill, has the board signed an agreement with that person regarding the CAFR bill?
Yes.
So that it would never come back upon us again?
Yes, we have.
So, okay.
We're
Well-
assuming that that's the way it is. It's-
Yeah.
it's-
Assumption's a bad word.
Right. We have a signed agreement with the homeowner that has taken responsibility for
So,
that.
as long as there's a signed agreement. And then, based on what you guys just approved tonight, $5,000 for Lisa, insurance of $27.93, the county at $26.50, grading, if you even do that one time, you just spent, without even Becky's bill, anything else, $15,543, of which we only have $13,100 and change. So we don't have money for grading once, much less twice, based on the bills that were approved tonight.
I had,
Not
when I
notwithstanding
did
that.
this, I had already taken out Lisa's business. So Lisa's been
That's
paying.
net of Lisa's bill.
Now,
Okay.
the 13,000, Lisa's already been paid, and that's the
Yes.
left.
Yes.
So you have 5, 6, 7, 8, 9. So you have 3,000 roughly. I mean, I'm just not doing the full math. But you have 3,000 left in the account, plus or minus, and that won't get you through the second road grading for the end of the year. Sure.
And we won't rate the
But you just got a permit. You're just gonna pay for a permit to do that twice a year. So that permit
We
will
have a
expire
permit
before you
that
have.
lasts for a full year.
Actually, the permit would allow you, the permit is 1 year duration. You could grade the roads every day if you wanted. It's not based on the number of times that you grade. It's a.
Per year,
it's
correct,
a-
but the CCNRs indicate that you have to do it twice a year, so then what's the advice, because they don't have money to do it
Well,
twice
they
a year?
indicate that people have to pay their dues too.
Well, no, I'm not disagreeing with that, but that still won't bring us in
We'll
enough,
bill
barely
out
enough
the-
money.
We'll bill out the next assessment.
I think
for the next year.
one thing I should add in here is we tried to have a little bit higher assessment, but we got caught up in that Title 33 rule that said you couldn't charge any more than 10 or 20% from the prior year. We kind of got caught up in that.
Grace, that's not true. It's our rules that say no more than 10%.
Yeah.
Okay, our rules.
Our CC's.
Our CCNRs, I'm sorry.
And I think if we calculate what you have, the grader, they'll only give you 30 days to pay. So if our last grade's in December, we should be getting some fees come in. The way I calculate it, you're within $100.
Yeah, we're fine.
Well, I think what you're alluding to, Suzanne, possibly that it may not be enough money in the assessment to cover our expenses.
Well, I'm concerned
So,
based
but
on-
here's what I'm adding to this, it's just something to take into consideration for us. We did incur unusual costs this year, the board did.
Last year.
Last year. I don't anticipate that's gonna happen in the future, so we don't know that we really are going to need to raise the annual at this point, because
That's
the
true.
dust hasn't cleared from the disputing. Hopefully, going forward, you'll be able to see clearer, and you won't, if you don't have a bunch of litigation going on and continue fighting, you're gonna see very clearly how much you actually need to raise. You can call a special meeting, we can sit down as a non-litigating group and agree to it, because we have to be able to. Huh?
Good luck with that.
Well, I know, but that's a start.
Well, Wayne, we're down to 5 people with litigation in this community now. Okay, I did the numbers, and we're down to 5. And it's gonna come to a time where enough is enough. And these are the same, we have one of the people that wants more assessments and doesn't even pay. And we have, and some of them are legit.
Yeah, but my point is, we don't need to raise the fees right now.
Right.
That's what practice.
Well, we
No, I think that was what we were.
No, what I wanted to make sure is that what was approved tonight, that we would have the money to cover it, based on what the numbers I was hearing. So minus Lisa's bill, yes, we'll have a few $1,000s sitting around. Having said that, though, we won't have enough for grading for the end of the year, on top of some additional things, and we don't
Sure, if
know.
that's what you were asking. or you
No,
considered.
I just wanted to make sure the board, I was looking at the numbers.
In
I'm more of a
2007,
kind of
the
person.
roads were graded once. In 2008, the roads were not graded at all. In 2009, the roads were graded once. In 2010, the roads were graded once. And in 2011, the roads were graded once. So to have to put us in a bind to have these roads graded twice in 1 year is not realistic. If we have the money, we do it. If it needs it, we do it.
And you have the dust
nobody's
permit, so you can grade
Well
them.
spoken.
And,
Well
yeah,
spoken.
people can.
Well, my
Well,
other
grade
concern is-
is out there and it has been graded.
Chris would be good to
Yeah, no, I'm going to buy our houses.
The CCNR shows the bylaws.
Everybody is contractors out, they got the
That
little
they have.
All right,
Graded twice a
and Guy is here, so if you guys have any questions,
But they know
Oh,
to-
one other, couple of
Oh,
other
yeah.
things. The mailbox is on Pima Road and Pinnacle Peak. It's a huge, I mean, it's 20 minutes drive from where we live out there. We need a mailbox up at 144th Street and Lone Mountain. It's gonna cost $100 flat fee, never to have to pay again, and right now we pay $105 per year. So to get a box up at 144th and Lone Mountain, it costs $100 flat fee and will forever be ours, and $4 for keys. So for $104, let's buy it.
and plus, don't forget, we just adopted a policy that if we have to drive to go get the mail or go get paperwork or go to do this, it's 55 cents a mile. So I don't think anyone's gonna have a problem with that.
Did we not pay for the whole year already, though? So
Yeah.
are we gonna
Yeah.
finish out the year before we
We,
do that? Then the next board could tackle, or the
Yeah.
year could tackle that.
Right, the sooner you pay it, the sooner you don't pay for mileage every day.
Yeah.
I
go by there
got
and-
this for $100 forever, so.
We're $100 forever.
But we're only talking a couple of months early, right?
Yeah, I mean,
We're talking, when is it?
yeah.
I would do it now, so people can start sending their dues next year.
Absolutely.
and
Is
then
there
they'll
room in
mail
that
them.
mailbox? Are there boxes available in that mailbox?
We walk around now.
Yeah, we had one question over here, and I forgot your name.
Suzanne.
Suzanne. Wanted to know if the CCNRs provide that the roads have to be graded twice a year, but you don't have the money to pay for the roads to get graded twice a year. You know, what do you do? Well, as a lawyer, I would tell you that you'd have to define for me what grading means, because I have a rake in the back of my truck, and I can go grade the living shit out of those roads right now and legally comply with the requirement relative to grading. And so I would meet the nature of your twice a year. If the association doesn't have the money to pay for grading, it doesn't have the money to pay for grading. You know, you can adopt a special assessment. It sounds like nobody wants to do that, and quite frankly, I agree with you. You guys have had so much litigation that just drained your resources, and once you get rid of all the lawyers, who said that? First thing we do is kill all the lawyers. And, you know, once you get past that litigation issue, then you'll start to be able to build a coffer, and you'll be able to have the roads graded twice a year.
Can you talk a little bit about reserves? And what's
I
required,
don't
because
know.
the banks do require a certain amount of reserve. when
But
they
for a
issue.
nonprofit, there's no requirement beyond what the board determines to be a reasonable reserve. So the board can determine that a reasonable reserve is $1.
This year.
And your, and I don't think you get to use this year as an example, but, you know, the board says we don't have the ability to have a reserve, then you don't. You know, your remedy is to call for a special meeting and vote, have the board replaced, and do all of that. You know, if you think your board's, again, they're just your voice, that's it. You know, if you think that a certain level needs to be established relative to a reserve, then, you know, now's your opportunity to raise your hand and say, hey, I have an open item that I want to have discussed. And I think that we need to have a 25% reserve for
extraordinary expenses as a reserve. And then, once that's out there, allow for discussion and the board can vote on it. And if you don't like the decision of the board, then you have the ability to remove the board.
No, I'm just saying that because in my, in some of my stuff lately, I did talk to a title company and there was some issue about certain banks requiring that. So you don't want to prohibit banks from not loaning to people that could potentially be buying homes in our
I
association.
have never seen it. I've never seen a bank impose their will relative to the underlying homeowners association as regards to your being able to obtain a mortgage. I've not seen that issue. And
I
do
just
a
heard
lot
about
of-
it, but
I do a lot of do a ton of litigation, but I also do a lot of property sales and the like. So a lot of real estate transactions. I've never had that issue come up.
Okay, we just have a couple more
Sure.
for Chris.
Yeah.
Oh, I was just wondering, speaking of reserves, since we're a nonprofit, if we reserve too much money, could we be reclassified as a for-profit?
No, you have to.
Okay.
No. It takes an awful long time for the IRS to catch up with that, and so long as it is a reasonable and prudent amount. What are your annual expenditures? Round numbers, 5,000, 10,000, 100,000.
10,000 for the roads, 3,000 for print.
50,000.
15,000 a year?
we're already
In
at,
2011, it was
Almost at 20 right now.
10,900.
Okay, so you're, first of all, you're under the $25,000 numbers, you don't even have to file your return. If you adopted a reserve that was on the order of 1 or 2 years, you would not be reclassified. And so long, and all you have to do is have the equivalent of a business purpose for it. So I'm going to bank, my assessments for the next 3 years so that 3 years from now, I have the ability to address your concerns, which are how do we build culverts across these things to avoid the roads erupting out all the time. As long as you have a reasonable need to retain the money, which you do, the anticipated litigation expenses would justify $650,000 worth of reserves, right? Okay, did I answer your question? Yeah. All right, next.
Bernie?
Yeah. So if I understood you right about an hour ago, the easements in front of the house that are dedicated to the roads are the property of whom?
I never said anything about easements. Did I? No, that wasn't me.
Okay, I'm asking you then. Since we
The
decided.
roads are dedicated.
The roads are dedicated, and we already decided that it's not Title 33, so they don't own the road, right? So-
we don't own the road.
You don't own the road, but you have a duty to maintain them.
No.
Yes.
The
Yes.
association doesn't own the road.
Correct.
Right. Theoretically, the property owner owns the road.
They do.
Right. So if somebody vandalizes that easement, we'll call it, vandalizes that easement, disturbs your easement, what's the story?
Okay, it's an easement. It's ingress and egress easement, okay? Platted, which means it can't be changed.
Right.
I would disagree with you can't modify the grade because you can do whatever the hell you want on your own land.
Okay.
Within reason, so long as you don't impede easement and ingress and egress.
So if you
So
paid,
what if somebody digs my easement?
If they dig it up,
Yeah,
what if I came into the middle of your living room and started digging
it's
it
the
up?
same thing, isn't
You'd be mad,
it? I'd be irritated.
just a little bit.
But if you graded your own front of your road,
No,
or
I'm not
if
talking
you,
about me grading it. I'm
No,
talking
if
about
you-
somebody saying, tough luck, you can't do that on that easement.
No. Look at the easement language itself. Right now, it's a dedicated roadway, so they can do things that are consistent with its purpose.
Sure.
Because that's, before you even bought your lot, the contractor came in here, did a master plat, and identified certain roads that he was gonna have constructed, and then he dedicated those,
Right.
that easement to the county.
Absolutely.
So,
No, not dedicated.
not to the
or
county.
to the association or whatever.
it's not really
Everybody has their own little
Yeah, dedicated.
common use of this particular easement. I
Yes.
haven't looked at easements, so I don't know what the language is. But if somebody comes in and interferes with its
There are
purpose,
exceptions
okay, what are they digging that for?
for spite. That's not a joke.
This is serious.
Then that's trespass, and you might have a cause of action for it.
Oh,
If
sure.
nothing, it is, if nothing else, it's nuisance.
No, it's beyond this.
No, the term is nuisance. It's a legal cause of action for nuisance. Okay?
So if someone has their road paved and I'm responsible to making sure it's graded and I take my grader tractor down their paved road and scrape it all up.
Soil seal.
Well,
No,
I
why
know,
would you
but
do that, Grace?
I wouldn't. But in the past, a board director took a $20,000 soil sealed road and graded it when they went to meetings and told them not to do it, da-da-da. And these people are angry because $20,000 just went out the door.
Angry too.
Yeah,
We do.
Guido. It was Guido that did it. And a lot of people are angry, they don't even want to hear the word association.
I don't know how to. I'm gonna go back to something that my mother and father taught me and what I learned in kindergarten. That's, treat other people the way you want to be treated.
Well, we're trying, we're getting back to
So,
that.
be a good-
A lot of healing.
That have not been done out here.
We have
What
some
if
people.
somebody tells you a road is too narrow in front of their house and they're afraid of accidents, whose responsibility?
Oh, yeah, that's a tough question. How wide is the road?
Why is it normal grip? It's wide enough, but they say people speed over it. It's dirt road, so they don't speed too fast, but if they do,
Do you have signs posted with a speed limit on the roads?
No, there aren't signs.
Do you have in your CCNRs, is there a speed limit? In your rules, is there a speed limit?
we should have.
You have not adopted a speed limit.
That's adopting rules. There you go. Adopt a rule, post a sign.
Yeah, I don't even know that, I'd have at least one sign, speed limit. But there is a statute on point that says, that the person is obligated to drive in a safe and approved manner.
And because insurance too that we have, I believe the insurance covers the easement on the road, so liability on the road.
It does?
It does, yes. That was one thing that we did check
And that's
on.
one of the things that insurance company told me that we didn't have to have, but,
You didn't have to have a speed limit?
that we didn't have to have the insurance, because it's the homeowner's already insuring it. But we've always had it, so it's never changed.
That's a slippery slope. You're well advised to have insurance.
It's part of the policy. That was the call that the board made when they
that's-
instituted that plan.
It's in that policy.
It's in that policy because we made the call on Joyce's phone that night of the meeting.
Any other questions?
We have some board members in these petitions that they have in front of the fire safety thing are saying that these roads belong to the homeowners association, that there's some kind of easements are part of ownership or something. So the association.
I don't know the answer to that. I have not looked at the underlying easements, nor have I looked at the merits of the complaints that Grace forwarded. Did not get into the detail and reach of them because I didn't care. I didn't need to get past the first step, which is this agency lacks jurisdiction to hear this complaint. That's all I cared about.
Guy, thanks for everything.
You're welcome. Have a great night.
Thank you.
Okay, the meetings, any questions?
I move right here.
You're good.
Adjourned.
You're very good.